Number 2. Pufendorf on the acquisition of property. Pufendorf gives very clear expression to the idea of uniting an object with one's personality. Discussing the transference of the right of property, he stresses that the concourse of the will of both parties is necessary. The transfer's volition is not sufficient. The recipient must consent. The object is physically separated from me, he says, and it would be out of order if it should be, so to speak, adjoined to me, unless I embrace it with my will and consent. The connection between my ego and the object is spiritual. To establish it, an act of will is required. But Pufendorf does not make the same use as Grotius of the idea of appropriation. Like Grotius, he holds that the right of property was introduced by a compact, but he differs from Grotius with regard to the preceding stage. He denies the possibility, assumed by Grotius, of uniting an object with the sum by means of simple appropriation. An antecedent agreement is always necessary. Pufendorf adheres rigidly to this principle. The argument was as follows. If principal appropriation were really sufficient to make the object mine, this could only be so in consequence of the terms of the original grant. It would presuppose that God had given men in common a right in a positive sense to all things on earth. Pufendorf's meaning is that God must have given men a common facultas moralis with regard to everything on earth. But this was not the case. The things on earth were given to mankind in the sense only that men were allowed to use them. Nobody had more right to them than another. Community of goods existed only in this negative sense. It was indeed impossible that men could have a facultas moralis in common over things on earth, for a facultas moralis is a power over another man's actions. The force of the right of property, vis domini, is such that we are masters over things that belong to us and can prohibit others from using them. God did not give the things to mankind in this sense. An indication of this is that God allowed the animals to use and consume things, Genesis 1:30. But there is no right of property for animals. If one animal puts something away for the future, the others are not prohibited from taking it. Pufendorf also adduces the case of Adam. He was allowed to make use of everything, but he had not the right of property to anything because there was nobody over whom he could have a facultas moralis. Therefore, if one of his sons collected more apples than he was permitted to, he did not steal, he was only disobedient to his father. In this way, Pufendorf shows that no facultas moralis could be directly derived from the original grant to mankind. It was left to men's own judgment how special rights were to be established. An agreement among them was necessarily acquired. Since men were equal, it was impossible to understand how the mere physical act of occupation could have the effect of excluding others from an object. An agreement must first be concluded if occupation was to create an individual right to an object. This is why it was necessary to assume that the right of property had been introduced by the human will. When speaking of the introduction of property, Pufendorf has in mind the general establishment of property rights. But like Grotius, he discusses a situation on the earlier stage when community of goods prevailed. Men could not make use of the fruits of the earth without collecting them. But it would be useless to collect the fruits if others were permitted to take them away. Therefore, the first convention among mortals is understood to have been to the effect that if someone had taken possession of things with the intention of making use of them, nobody should take them from him. If there had been no such convention, men would have had to abstain from using anything at all. At this pristine stage, the community of goods was tempered. There was a mixture of community of goods and right of property. The substance of things was common to all, but the fruits belonged to him who had collected them. The oak belonged to nobody. But if I picked up an acorn, it became mine. This followed from the primeval convention. Only gradually were separate rights of property established by compacts in response to the requirements of changing conditions. To sum up, Pufendorf's argument is that the good things on earth could be of no use to men unless they acquired a right of property in them, that this right could not be directly derived from God's original grant, that it could not be created solely through occupation, and that the agreement among men was necessary to give rise to the right of property. He draws the conclusion that the principle of sum cuique did not become applicable with regard to things until it had been determined through a convention what belonged to whom. Thus, Pufendorf did not accept the idea of Grotius that the sum could be extended to encompass external objects without a preceding convention. Number 3. Locke on the acquisition of property. Locke makes the same general assumptions as Grotius and Pufendorf. Men are naturally in a state of perfect freedom to order their actions and dispose of their possessions and persons as they think fit. Man is absolute lord of his own person and possessions. There is a state also of equality wherein all the power and jurisdiction is reciprocal, no one having more than another. But the state of nature, though a state of liberty, is not a state of license. It has a law of nature to govern it, which obliges every one, and reason, which is that law, teaches all mankind who will but consult it, that being all equal and independent, no one ought to harm another in his life, health, liberty, or possessions. This is the principle sum cuique tribere. At the same time as being the dictates of reason, the law of nature is the will and commands of God. The law of nature is violated when somebody makes an attack on the life, liberty, or possessions of another. The consequence is that he exposes himself to the reaction of the offended party. He forfeits the protection of the law of nature. Locke's mode of expressing this is that the offender puts himself into a state of war. He declares himself to live by another rule than that of reason. He has declared war against all mankind, and therefore may be destroyed as a lion or a tiger. He has exposed his life to the other's power to be taken away by him, the offended party, or anyone that joins with him in his defense. Everyone has a right to punish the transgressors of the law of nature to such a degree as may hinder its violation. In one passage, Locke claims that the reaction has to be proportionate to the transgression. But later this limitation seems to be discarded. I may kill a thief, Locke says, when he sets on me to rob me, but of my horse or coat. The state of nature is, however, unsafe. Men will not accept the law of nature as binding to them in the application of it to their particular cases. Moreover, there are no independent judges. Everybody is a judge unto himself. But he may lack the power to give due execution to the law of nature. These are the reasons why men are willing to quit the state of nature. They unite for the mutual preservation of their lives, liberties, and estates, which Locke calls, by the general name, property. The preservation of their property is the great and chief end of men's uniting into commonwealths and putting themselves under government. This corresponds to the statement by Grotius that society has been formed with the object of preserving the sum for everybody. What Grotius calls the sum, Locke calls a man's property. Originally, he used the term propriety, though he later exchanged it in most places for property. Propriety seems to have been the usual word in the 17th century. It was employed by Hobbes, Filmer, and others. The connotation was primarily that which is proper to a person, proprium aliqui sum, or that which belongs to somebody. What belonged to a person was not in the first place physical things. It was his life, limb, and liberty. In the second treatise, Locke says, by property, I must be understood here, as in other places, to mean that property which men have in their persons, emphasis supplied, as well as goods. This was in accordance with 17th century usage. Of things held in propriety, Hobbes says, those that are dearest to a man are his own life and limbs, and in the next degree, in most men, those that concern conjugal affection, and after them, riches and means of living. Laslet records that Locke's contemporaries could talk of the Protestant religion established by law as their property. Richard Baxter, writing before 1680, said that every man was born with a propriety in his own members, and nature giveth him a propriety in his children, and his food, and other just acquisitions of his industry. He also said that men's lives and liberties are the chief parts of their propriety. Locke, too, regards life, limb, and liberty as the core of one's property. But just as Grotius did, he thought that the sphere of property, or sum, could be extended to encompass physical objects. The problem of the acquisition of property was the problem of how such enlargement could be achieved. The solution was presented in the famous Chapter 5 of the Second Treatise. As mentioned above, it has been suggested that Locke used the term property in two meanings, both as signifying the material possessions, or units of the conveniences or necessities of life, and, in an extended meaning, as lives, liberties, and estates. Locke's use of the word is not consistent. There are two connotations which are not distinguished by Locke himself. One is that which belongs to a person, or that which is a person's own. In this sense, the word property refers to the objects included within the spheres of the sum. The other connotation appears, for instance, when Locke talks of how property in the earth itself is acquired. Here, property signifies a right to land, not the object of that right. The extended meaning suggested by Viner refers to the denotation of the word property when used in the former sense. But it is turning things upside down to say that the meaning is extended when life and liberty are comprised within a person's property. Life, limb, and liberty are from the beginning his property, but the sphere of his property can be extended to encompass material things. Number 2, the biblical foundation. The ultimate ground why men could acquire things as their own was the original grant of God to mankind. This was the common assumption of Grotius, Pufendorf, and Locke. Only by the will of God could men have come to possess any things on earth as belonging to themselves. Therefore, the terms of the original grant were of fundamental importance. Since they were set out in Genesis 1:28-29 and chapter 2, verse 9, the interpretation of these passages was decisive for the basis of the doctrine of property. On this point, there is no discernible difference of opinion between Grotius and Pufendorf on the one hand, and Locke on the other. All of them held that God had given all animals and things on earth to men, in common, without any special right for anybody. Locke had therefore no occasion to argue against Grotius or Pufendorf concerning God's grant. But Filmer had a different opinion concerning its terms. Locke, in his first treatise, put forward his arguments against Filmer. Filmer interpreted Genesis 1:28 as implying that Adam, by donation from God, was made the general lord of all things, with private dominion to himself, and the right of donation, assignation, or cessation. At the time of the flood, Noah was left the sole heir of the whole world. It is not probable, Filmer says, that God abrogated his donation to Adam and instituted a community of all things between Noah and his sons, as Selden would have it. Filmer finds it most reasonable that Noah himself, as Lord of all, was the author of the distribution of the world, and of private dominion. Locke refutes this theory by applying a principle of the common law to the original grant. The argument is that if God had made a personal donation to Adam of the whole world, Adam's rights could not have been inherited by his children, for a positive grant must be interpreted strictly in accordance with the express words used and cannot confer any right beyond that. Therefore, at Adam's death, the donation would have reverted to God. This, Locke obviously thinks, would be an unacceptable conclusion. Filmer has nothing more of a positive kind to say on the origin of property. Locke had therefore no reason to argue any more against him on that question in the first treatise. As we shall presently see, there is a brief reference to Filmer in the second treatise. For the rest, Filmer's doctrine is without importance to Locke's theory of property. Laslet contends that Locke's chapter on property was written with Filmer's works in mind, and as a direct refutation of them. This is unlikely. In Laslet's opinion, Locke had in mind a passage in Patriarcha where Filmer argues against the theory that the rights of property was introduced by a compact. The passage runs as follows. Certainly it was a rare felicity that all men in the world at one instance of time should agree together in one mind to change the natural community of all things into private dominion. For without such a unanimous consent, it was not possible for community to be altered. For if but one man in the world had dissented, the alteration had been unjust, because that man, by the law of nature, had a right to the common use of all things in the world, so that to have given a propriety of any one thing to any other had been to have robbed him of his right to the common use of all things. This is one of the many arguments which Filmer proffers against Grotius' assumption of the original community of goods. Filmer wants to show that if community of goods had really existed from the beginning, it could not have been replaced by private property through a compact. For this would have required consent by every man on earth, which, Filmer implies, could never have been obtained. Therefore, the theory of original community of goods is false. This theory of Filmer held to be an error which the heathens taught. If Locke had intended to refute Filmer's doctrine in Chapter 5 of the second treatise, he would have argued in support of his own theory that God had given the earth to men in common. But there is nothing in Chapter 5 on that point besides a few words in the beginning. As regards Filmer's argument against Grotius that the right of property could not have been instituted by a compact, Locke could have had no objection. He reasoned in a similar way. It would have been impossible, he thought, to obtain the consent of all men on earth.